You personally met with Ms. Mangum on March 16, 2006.
Correct.
Now, did you, and you met with her subsequently, correct?
Correct.
And when you met with her on March 16, 2006, explain what her demeanor was as far as talking to you. Did she appear to be impaired?
On the 16th?
Yes, sir.
No, she did not.
Did she, in any of the subsequent meetings in the initial part of your investigation, either personal meetings or on the phone, did she ever appear to be impaired by any alcohol or impairing substances?
No.
Did you have an opportunity to review the photo presentation that occurred on April 4th, 2006?
Yes.
And you observed Ms. Mangum in that photo presentation, correct?
Correct.
Did her actions in that photo presentation, is that consistent with the way she acted when she was around you?
Yes.
In the initial part of the investigation?
I mean, her reactions were the same that I had seen before.
Okay. At some point in time, back in March, you saw a different Crystal Mangum than you'd ever seen before. Is that right?
Excuse me?
Sometime in March of 2007, you saw a different Crystal Mangum than you had ever seen before. Is that correct?
I don't know if it might have been in April, I believe.
All right. It may have been April 4th, back on page 43?
Yes.
And you basically...
March of 2007?
2007. And on page 43, you are describing a day where you were supposed to meet with Ms. Mangum with representatives of the Attorney General's office, right?
Correct.
And you went out to pick up Ms. Mangum, and she wasn't there originally, right?
No, she was not.
And did she eventually show up?
Yes.
At that point in time, did she appear to be impaired?
Yes.
What observations did you make that led you to believe that she was impaired on that particular day?
She wasn't walking right. When I spoke to her, she was very lackadaisical. She wasn't making any sense of some of the comments that she was saying to us.
And did you indicate in your notes that I noticed her eyes were wandering and her demeanor was different than any time I've been around her? Is that correct?
Correct.
And so from the time you met her March 16, 2006 up until April 4th, 2007, her demeanor was consistent with what you saw in the photo presentation, correct?
Correct.
Was the written report that you provided and went through with Mr. Nifong at that meeting consistent with what he had requested you to do?
Yes. He wanted to know, again, for the purposes of a proceeding, he needed to have the information, as he conveyed to us, the information that showed the matches that we had identified to that point of the testing. And that's what this report does, in addition to other things. But that's what's the thrust of this report.
Okay. And did you consider this May 12th report to be a final conclusive report in this case?
No.
And why did you not consider it to be a final conclusive report?
Well, because in discussing this report, it was clear to us that, in fact, Mr. Nifong explained there would be additional specimens coming forward, and so there'd be more work to be done, that this report was for a proceeding leading to the trial, and in fact, we would need a final report at a later date. There was, I don't remember the exact quotes in the conversation, but there was no question that this was not a final report.
And did you in fact receive some additional either evidence items or reference specimens after May 12, 2006?
Yes, we did.
And if you'll look you can look at it on yours if you want. I think it's Exhibit 237 that we had up before that talks about where you summarized what evidence items you've received. Can you show that 237? Do you have page 2? Okay. Can you go up to the last page? Okay. And it indicates there on the last page that you received. Well, tell me what it indicates.
Well,
we
received a reference specimen on May 17th number 15931, and we received another specimen on June 27th, number 16062.
Okay. In Mr. Nifong's initial response to the grievance committee in this matter, which has been admitted into evidence, Mr. Nifong represented that he told you to prepare, and I'm quoting now, a summary report listing the items tested, the test performed, and the results of the test. In other words, a report similar to the SBI standard report. I want to ask you about that representation to the grievance committee. Dr. Meehan, did Mr. Nifong request that you prepare a summary report that would include all evidence items, tests performed, and all results of those tests to date?
No, he never specifically detailed to us what he expected to see in the report, like what you're saying.
Okay. And did Mr. Nifong ask you to prepare a written report containing the same types of information that would be included in the SBI summary report, or any words to that effect?
To my best recollection, he never referenced the SBI report.
And did you have a copy of the SBI report in your file?
Yes.
And did you have that copy of the SBI report in this case by the April 21st meeting when Mr. Nifong asked for the written report?
He didn't ask for the written report on April 21st. We talked about the report, but he didn't ask for it until we called.
Okay. When he first brought up the getting a written report.
Right.
And did you have the SBI report by that time of that meeting?
Yes.
Did Mr. Nifong ask you to prepare a report in any format that included all the results of your tests and examinations conducted to date?
No. The only thing that Mr. Nifong conveyed to us was not specifics about what to be included in the report. And that's not unusual. I mean, it's expected that I should know what's in a report or what needs to be in a report. What he conveyed to us was that, again, he had a proceeding coming up which he would need a report that specifically addressed the matches that were identified to date. It was a proceeding in preparation for the trial. It was not to be considered a final report. And in addition to that, there were more specimens coming down the road.
And is the format of your report that you went through with Mr. Nifong that we were looking at page by page on the May 12th, is that different than the format of the SBI summary report?
Yes, it's very different.
Okay. I want to just take a look and compare those. If you can show Exhibit 209, page 7. This is Exhibit 209, page 7, if you want to look at it in notebooks instead. Do you see that, Dr. Meehan?
Yes.
And do you recognize Exhibit 209 as the SBI report that you had for this case?
Yes.
In that, and is page 7, is that where the results of the testing are listed for the SBI?
Yes. It says results of examination.
Okay. And are there any DNA profiles in the report the SBI provided to Mr. Nifong in this case? That's Exhibit 209.
No, they don't specifically list the profiles in the report, and it's not required to list profiles in the report. We do it at DNA Security because we think it's helpful.
And the report that we were just looking at, your May 12th report, that does list out specific DNA profiles for all three of the matches that you listed in that report.
Yes, it does.
If you look again at Exhibit 209, does the SBI report provide results for DNA found that does not match any of the reference specimens?
Well, on the very last paragraph, they have a statement where they say that they cannot draw any conclusion with regard to matches to reference specimens.
Okay. So did they find in that report that there was DNA, but they couldn't match it or draw any conclusions about whether from a reference specimen?
In that statement, that's what I believe that means.
And does the May 12th
They also list a couple of other locations on their results where it says when they exclude the victim from a match in a number of locations. They'll match a stain to a suspect and then explicitly state that it doesn't match the victim.
For example, if you look on the second paragraph there, they talk about profiles obtained from a towel. Do they indicate whether or not it matched any of the players or the reference specimens?
Yes, they do.
And do they also talk about whether or not it did not match any of the other items?
Yes, it says it did not match the victim or the DNA profiles from the swabs from the suspects, and then it gives the numbers, which probably includes all the suspects that they have.
And from reviewing this report, did you understand whether for any piece of evidence item that found DNA, whether they specifically noted whether or not it matched all the reference specimens they had?
Yes, Yes, that's what this says.
And does the May 12th report that you provided and went over with Mr. Nifong list those types of results where it says that it did not match or that there are no conclusions?
We have a statement in our report that says we have profiles that do not match, but we don't list those evidence items like they do here, where they actually name the specific items.
And why did you not have specifically noted what evidence item was referenced and whether or not it matched any of the specific?
Well, it wasn't whether or not it matched. We listed, again, our client needed this information for a proceeding, that information being what evidence matched what reference specimens. Now, on its surface, this is not at all unusual to us or in an investigation, where a prosecutor or investigator want to know, what do I have to match the data? I need to know as I build my case. And so that's what the report provided. The report was not intended to be an all-encompassing, conclusive report of all the work we did. We did, I shouldn't say we, I should say I did attempt to make it clear that there is other information here. It doesn't match anything, but it is here, and everybody should be aware of it. And that we did not list that by detail. Had it been a final conclusive report, it would have been listed.
And we'll come back and talk about that in a second, but after going through the written report that you prepared on May 12th, would it have been obvious that you had not provided Mr. Nifong with a summary report like the SBI report we're looking at here?
Objection. Formal question. If you can rephrase that, Mr. Brock.
You said you went through your report with Mr. Nifong on May 12th. Which page is it?
That's correct.
And is the format of that report consistent with the SBI report?
Overruled.
The format of our report is similar in that we list the items that were received and examined. Where the two reports differ is in how we display the results. On our report, we show in detail, you've seen the charts of the profiles of the matches and the evidence and the suspects that make those matches up. The SBI report doesn't do that. And so that's, I think, is the most obvious difference between the two reports.
There's no profiles anywhere in the SBI report?
No, there's no listing of profiles.
Are there any profiles in the SBI report anywhere?
No.
We talked about the additional reference specimens that you received after May 12th. And did you conduct additional analysis on those items?
We did the same type of testing we did on all the other specimens.
When approximately was the additional analysis completed on those two additional reference specimens?
On near the end of May and in August. No, July. I'm sorry, July.
And did you, when you completed that analysis, did you call Mr. Nifong or his office with the results of that testing?
Yes, after each one. They were completed individually. So at the end of May, we called Mr. Nifong. When the first one was completed, we called Mr. Nifong's office to let him know we had completed that analysis and we've made the comparisons, and we asked what they would want us to do from that point.
And did you ask whether or not Mr. Nifong wanted a written report issued from
Yes,
those additional?
I did. And when I called, I didn't speak with Mr. Nifong. I spoke with Mr. Himan on both of these occasions. And I did. I asked if they would like a report issued at that point. And on that initial phone conversation, Mr. Himan said he would check with Mr. Nifong and he'd get back to me, and he did. And I was told that I would not need to issue a report.
Investigator Himan came back and told you would not need to issue a report.
That's correct.
And when approximately was all the testing and analysis completed in this case?
Approximately the middle of July, about the third week of July.
And did you issue a final conclusive written report with all the results of tests and examinations after those were completed?
We did. We have eventually issued a report.
I'm sorry. Prior to, let me give a time frame to my question. Prior to January 12th, 2007, which is when Mr. Nifong recused himself from the criminal case, did you ever issue a final conclusive report with all the results of the tests and examinations after they were completed?
No, we never did.
And why not?
Well, we were never asked. We didn't really know what was going on with the case. We don't typically force-feed reports to clients. And so we were in a holding pattern. We were waiting for someone from Mr. Nifong's office to call and let us know that we could do that. We could issue a final report at this time.
Prior to January 12, 2007, did Mr. Nifong ever request that you provide him a final conclusive written report with all the results of the tests and examinations?
No.
And did you expect Mr. Nifong to request a final written report with all the results?
Of course we expected that to happen at some time. That's what happened. That's standard. But it was in opposition to drive the case. When he was ready for the final report, we thought he would let us know.
State Bar calls Bradley Bannon.
Your testimony would be the truth, the whole truth, and nothing but the truth, so help you God.
Good evening, Mr. Bannon.
Good evening.
Can you state your full name, please?
My name is Bradley Joseph Bannon.
Can you spell the last name for the court report, please?
It's B as in boy, A-N-N-O-N.
Where are you currently employed?
Cheshire, Parker, Schneider, Bryan, and Vitale. It's a private law firm here in Raleigh.
And how long have you been practicing law?
It will be 10 years in August.
What type of law do you practice?
Criminal defense.
And how long have you practiced criminal defense?
For The entire time I've been a lawyer, which is almost 10 years.
Sorry, didn't you speak up?
Oh, I'm sorry. The entire time I've been a lawyer, which is almost 10 years.
And are you a member of any professional organizations or associations?
Yes.
What are those?
I'm a member of the North Carolina Bar Association, the American Bar Association, the National Association of Criminal Defense Lawyers, and the North Carolina Academy of Trial Lawyers.
Do you currently hold any position in those associations?
I'm the legislative chair for the criminal justice section of the Bar Association here in North Carolina, and I will be next week, inducted chair of the criminal defense section of the North Carolina Academy of Trial Lawyers.
And in your first position you mentioned, have you had any involvement with the recent legislation involving open file discovery statutes?
Yes, there have been efforts recently to clarify some conflicts that exist between current law and old law that were raised by the Conference of District Attorneys. There was a delegation of the Conference of DAs that worked with Joseph Blunt, Cheshire V, and I on issues related to that. We came to an agreement about that type of language, us on behalf of the defense bar and the delegates on behalf of the Conference of DAs, and I believe that language will be in the legislation that's being moved forward this session.
At some point last year, did you begin representing David Evans and his family in the investigation of what is commonly known as the Duke Lacrosse cases?
I did.
And when approximately did that representation begin?
My involvement in that representation began on March the 28th of 2006.
And generally, what was your role in representing Mr. Evans?
Well, Joe Cheshire is my senior partner, and he was lead counsel for the Evanses. He had already met with them before, and shortly after he did, he asked me if I would be willing to work with him on the case. We do that a lot, so of course I said yes, and from that point forward, my involvement was, as it often is in those types of cases, which is to primarily receive and process and analyze discovery usually, and help Joe with getting together investigations or whatever things we need to do, expert testimony and that, and then help him try the case if necessary.
And in the context of those cases, were you involved with meeting with other defense counsel for the defendants or potential defendants?
Yes, often.
During the investigation and after the charges were filed, did counsel for the defendants have regular discussions and meetings about the case?
Yes.
And generally, what was the purpose of those meetings?
Well, the purpose of the meetings was, there were lots of different purposes. We all had different clients, but we all had a common goal. We were all united in our approach to the case, and so we would often meet with each other about what was going on in the case. It was, I think the word unusual has been described or has been used to describe the case a number of times in these proceedings, and it was unusual in every respect. And it required us to have lots of meetings and conferences about what was going on in the case, both inside the courtroom and outside the courtroom.
And when letters or motions were drafted for Mr. Evans, generally, were you involved in drafting those documents?
Yes.
And did that sometimes include documents signed by Mr. Cheshire or jointly by you and Mr. Cheshire?
Yes.
After you became involved in that investigation, do you recall Mr. Nifong beginning to make statements to the news media?
I actually think Mr. Nifong started making comments to the news media before I became involved. My recollection was maybe there was a day or two there where I had started to see things in the media about it, and the comments that were attributed to him about the case. And then shortly after that, I became involved in it.
And generally, what was your reaction to Mr. Nifong's initial statements to the media in the investigation?
Well, I had two different reactions. The first was I thought they were outrageous. The types of things that I was hearing about a rape having occurred and it been racially motivated and all kinds of people were involved, and if they weren't involved as principals, they were involved as aiders and abettors, and if they didn't come forward to talk about what happened there and a rape having happened, that they could potentially be charged as aiders and abettors, and that was really my first reaction. My second reaction is, wow, there must have been a rape at that house that night.
And why do you say that? Why did you have that reaction?
Well, because I could not have imagined a prosecutor speaking in such certain terms about his confidence and referring to evidence in the process about a crime having occurred and why it occurred without him having absolute and complete concrete evidence that it occurred.
Can you look at Exhibit 101 in the notebook, please?
Sure. I'm messing it up.
Probably towards the front.
Okay.
Did you become familiar with the comments made in Exhibit 101 in your representation of Mr. Evans?
Yes.
Can you read, it's just a one-page article, can you read the comments in that article, please?
Just from the beginning?
Yes.
Durham's district attorney is speaking very candidly about what could happen to anyone charged in the alleged gang rape at a party last week. Quote, in this case where you have the act of rape, essentially a gang rape, is bad enough in and of itself, but when it's made with racial epithets against the victim, I mean, it's just absolutely unconscionable, said District Attorney Mike Nifong. Investigators say several members of the Duke Lacrosse team made the racial slurs to the two black women hired to dance at the house party. Quote, the contempt that was shown for the victim based on her race was totally abhorrent, Nifong said. It adds another layer of reprehensibleness to a crime that was already reprehensible. Nifong tells Eyewitness News that he may consider adding hate crimes to any other potential charges if investigators determine the victim was targeted because of her race. For now, investigators in the district attorney's office are focusing on identifying the suspected attackers who could be charged with first-degree rape and first-degree sexual offense. I don't think you can classify anything about what went on as a prank that got out of hand or drinking that took place by people who are underage, Nifong said. He may also consider charging other players for not coming forward with information. Quote, my guess is that some of this stone wall of silence that we have seen may tend to crumble once charges start coming out, Nifong said. As of Monday, Nifong said no player has contacted him with new information. Swabs containing the DNA taken from 46 players last Thursday arrived at the SBI lab Monday afternoon. Results are expected back next week. Nifong says he will not file any charges until the results are in.
Are those the statements or types of statements to which you became familiar and had a reaction to, you just discussed?
Yes.
In particular, Mr. Nifong's comment, and the date of that article is March 27, 2006.
Right, that was the day before I became involved in the case.
And once you became involved, were you aware of the comment that Mr. Nifong made about a stone wall of silence?
Yes.
And once you became involved, did you believe that Mr. Nifong's statements in that article about a stone wall of silence were truthful?
No, they were untruthful.
And why is that?
Because David Evans, who ended up being my client, and Matt Zash and Dan Flannery, who lived with him at 610 North Buchanan, had cooperated fully essentially in every way that they've been asked to. When any figure of authority, whether it was a figure of authority from Duke University or the Durham Police Department or the Durham District Attorney's Office or anybody acting on their behalf had asked Dave Evans to do anything or say anything, he had done it. Most especially, that was illustrated on March the 16th, which has been discussed here as the night that the search warrants were executed at his house.
And did you become familiar with the statement, the written statement that Mr. Evans gave
yes.
the police that night?
Mm-hmm.
And does it set forth, well, what generally does it set forth?
The written statement he gave after he had given an oral statement in an interview. And essentially what he was asked to do after the oral statement was given is write it down. And so he wrote down in as great a detail as he could remember everything that had happened that night from the period of time that he was asked. And by that night, I mean the night of March the 13th when this party happened at his house. He wrote down the details of exactly what he remembered, to the extent he could remember it, who he remembered doing certain things, who he remembered taking certain digital photographs that he offered up as evidence out there about what had happened. And at the end of that statement, he listed, to the best of his recollection, the people who were at the party, and he included in that list and told investigators that it included people who weren't lacrosse team members, at least 2 or 3 people there who weren't on the team. And he also parenthetically throughout there would note on that list how he remembered certain people doing certain things.
And from your review of that, does Mr. Evans's written statement include any non-flattering descriptions of some of the conduct that took place at that party?
Sure.
And did you have an opportunity to review these written statements that were given by the other 2 residents of the house in the course of your representation?
I did.
And do those statements also describe similar type of unflattering type conduct?
Certainly.
Do you know whether or not those 3 people were interviewed individually or together?
They were interviewed separately, and I think Investigator Himan interviewed Dave Evans and Dan Flannery separately, and I think Sergeant Gottlieb interviewed Matt Zash separately.
And from your review of those statements, did any one of the residents provide any statements or information to indicate any type of sexual assault occurred on that evening?
No, in fact, they denied it.
And did they indicate whether any kind of sexual activity of any sort took place between any of the players?
No, in fact, they denied it.
Just hang on one second, Mr. Chairman. Could you please play, I want to show you a video of some information and ask you if you recognize that. Could you play Exhibit 144B, please?
And yet you're out there saying not just that 3 of the boys are guilty, but they're all guilty.
I do recognize that.
144B.
That some of these people have not been cooperative, have they?
Well, you need to understand that Mr. Zash is one of the 3 young men who actually rented the 610 Buchanan address where this assault took place. And those 3 young men did come down pursuant to an invitation from the police department. They did make written statements. They listed the other people who were present. They did voluntarily consent to having suspect kits taken. So in that sense, those 3 young men were in fact cooperative. Now, if they made statements that were not true during the course of this, then obviously to the extent that the statements were not true, that would not be cooperative.
Is there anything
Is there
anything you know for certain at this point that is not true?
Well, they denied that a sexual assault took place inside that residence. And the position that the state is taking is that that is not a true statement. And I would go on to say that none of the other members of the team, other than these 3, have made statements to the police.
Were you aware of that comment that Mr. Nifong made on Dan Abrams' show?
Yes.
And what was your understanding about what Mr. Nifong believed was cooperation or non-cooperation of your client?
Cooperation for Mr. Nifong was somebody saying that a sexual assault had occurred.
Can you take a look at Exhibit 110, please? And look at page 2.
Okay.
Can you read the first full paragraph on Exhibit 110?
Yes, this is a quote. If it's not the way it's been reported, then why are they so unwilling to tell us what, in their words, did take place that night, Nifong told Smith on Thursday. And one would wonder why one needs an attorney if one was not charged and had not done anything wrong.
Wait a minute, 110?
Sorry, 110, page 2, first full paragraph.
Oh, second page.
I'm sorry. Can you read that again, Mr. Chairman?
No, I can read it.
Just hang on one second.
That's all right. You don't need to repeat it.
And were you aware of that statement during the representation of Mr. Evans?
Yes.
And what's the date? What was the date of that article?
March the 31st.
And what was your response to particularly the second sentence that was in Exhibit 110?
You mean what did I think when I read it?
Yes.
I mean, again, I can't. It's outrageous. I mean, a comment by a criminal lawyer, let alone a prosecutor who knows about his duties, to comment negatively and pejoratively on talking to an attorney, I just don't even understand. I mean, it's nothing that anybody would ever be able to get away with doing in a court of law, commenting negatively on that exercise. And it basically says to the public, if these young men go and get a lawyer, then they've done something wrong.
And with respect to the first sentence in that paragraph, in light of your client's actions, did you feel like that was a truthful statement that Mr. Nifong made?
Well, it's not a truthful statement in light of my client's actions.
And did Mr. Evans, what was his reaction to the police when he was first confronted with it? The allegation that there had been a sexual assault against Ms. Mangum.
What was Dave Evans' initial reaction when he was first confronted with that?
Yes.
Well, he told them it didn't happen. He tried to tell them while they were executing the search warrant that it didn't happen, and said, I want to give you my statement. I want to tell you all about this. And they kind of held him off while they continued to do their work and process his house. And finally, they took him down to the police station to talk to him, and he did so. He did not call a lawyer when he did so. He didn't call his parents when he did so. He went down and he answered every question that they asked him orally, and then he gave a handwritten statement after he did that. And I think following that, he offered to take a polygraph examination. He was refused when he made that offer, and was told that DNA evidence was a lot more solid and could really prove whether this had happened or hadn't happened. So would he submit a sample for DNA testing? And he said absolutely. I think hair samples were asked of him, and he submitted hair samples. He also submitted to photographic ID procedures. I mean, he did everything that they asked him to do.
Okay. Were you familiar with the non-testimonial application and order that was entered in this case with respect to the players?
Yes.
And there's been some testimony. Have you been here today and yesterday for the testimony?
Yes.
Did you hear testimony about a sentence in the non-testimonial order about what the DNA would do in this case?
Yes.
And what do you recall? And if you need to look, it's Exhibit 203.
I don't need to look. It said that DNA testing would exonerate the innocent and implicate the guilty.
Okay. And can you look back at Exhibit 110, second page, right below the paragraph that we just read, and read those next two paragraphs, please?
Yes. If the state crime lab's DNA analysis proves inconclusive or doesn't provide a match for any of the athletes, Nifong has said he'll have other evidence. Quote, if the only thing that we ever have in this case is DNA, then we wouldn't have a case, Nifong said Wednesday.
And when you read that, did you think that was consistent with the statements in the non-testimonial application in order?
No.
And were you here just previously when Agent Lynn testified about the conversations that she had with Mr. Nifong?
Yes.
And do you recall her testifying that that took place on March 30th?
Yes.
And do you recall her testifying that Mr. Nifong was told that the results of the rape kit item were negative?
Yes.
And what is the date of this article from which you were just reading that statement?
The date of this article is March 31st.
That's the day immediately after the phone conference that Mr. Nifong had with Agent Lane and other people at the SBI.
Yes.
After you began, or you became aware of these extrajudicial statements that Mr. Nifong was making with the press, did you and or Mr. Cheshire take any action or make any attempts to communicate with Mr. Nifong?
Yes.
And how do you recall that was first done?
Well, the first attempt that we made was to communicate with Mr. Nifong at all, and Mr. Cheshire, and this may have even been a day or two before I became involved in the case, Mr. Cheshire had asked Moira Bitzenhofer, who is his paralegal, to try to make contact with Mr. Nifong's assistant in Durham to see if he would be willing to sit down and have a conversation about the case, since at that point in time Joe had come to represent David Evans.
Okay. And what was the response that was received from Mr. Nifong to that attempted communication?
Well, his assistant asked Ms. Bitzenhofer to hold and was gone for quite some period of time, and came back and said that she had a verbatim message that she needed to deliver from Mr. Nifong, and that the message was that essentially if Joe Cheshire would like to talk to me about this case, he can have his client, he can bring his client to the Durham Police Department and have him charged. Other than that, I don't have anything to say to him about that.
Okay. And after your office received that response from Mr. Nifong, did anybody follow up with any kind of oral or written communication?
Yes.
And can you take a look at Exhibit 205, please?
Yes.
And can you identify that and tell the panel what it is?
Well, the first page is a fax cover sheet that reflects that the letter that follows the cover sheet was sent from Joe Cheshire to Mike Nifong on March 30th. The letter itself is a letter that Joe Mr. Cheshire drafted and asked me if I would review, which I did, and after reviewing it, we faxed it to him.
Okay. And does the first page indicate that a fax confirmation was received back from Mr. Nifong's office on March 30th?
Yes.
And is the attempted contact that was made, is that memorialized anyway in that letter?
Yes.
Can you direct the panel to where that is?
It is in the first two paragraphs.
Okay. And does it recite what you've just testified to about Mr. Nifong's response to the attempted communication?
Yes.
Specifically, what does it say?
My paralegal, Moira Bitzenhofer, called your office yesterday afternoon to request that I be given the courtesy of a meeting with you or a telephone conversation with you on that topic. However, through your assistant, Sheila Eason, you denied that request. You and I have known each other for a long time, and I do not mind telling you that I was amazed at that response. In 33 years, I have never seen such a request denied by a prosecutor, nor in such a manner. Your responsive comments reported to Ms. Bitzenhofer by Ms. Eason verbatim seem to suggest that I should call the Durham Police Department and have my client charged with a crime before you would have a conversation with me on a topic you have demonstrated no reluctance to discuss with myriad local and national news reporters over the last several days.
Does Mr. Cheshire in that letter say anything about additional communications if that response was misunderstood?
Yes.
And where is that in the letter?
I think it's the last paragraph.
Okay.
But would you like me to read that?
That portion, yes.
Sure. Well, it deals with other matters in the letter itself, too, but it says I guess the last sentence, and if I did misperceive your rejection of my request for a meeting, please accept this letter as a formal written request to meet with you at your convenience.
Okay. What are the other matters that are set out specifically in Exhibit 205, the March 30th letter?
It refers to the public comments that Mr. Nifong had been making for several days at that point in time.
Okay. And does Mr. Cheshire set forth some of those comments that he's seen that have been reported?
Yes. He gives examples of some of the comments which were, just 2 or 3 of what was being made at the time, and then goes on to discuss the nature of those comments and issues related to those comments as it relates to the proceedings and the rejection of our request for a meeting.
And does Mr. Cheshire in that letter to Mr. Nifong set forth concerns that he has about the extrajudicial statements that Mr. Nifong is making to the press?
Quite clearly.
Okay. Can you read an example of those concerns that he expressed?
Well, after giving certain examples of those quotes, the text of the letter is, in essence, before the first charge in this matter has been brought against the first person, your reported public comments have announced the criminal guilt of potentially dozens of people for committing a racially motivated gang rape, effectively saying they are equally guilty as principals or aiders and abettors. The comments have inaccurately suggested that no one has cooperated with law enforcement when you know that at least 3 of them, including my client, submitted to the search of the alleged crime scene and without asking for lawyers gave lengthy oral and written statements to law enforcement. Moreover, in addition to being patently false, your comments about the failure of anyone under suspicion to speak to law enforcement represent the type of negative comment on the exercise of Fifth Amendment rights you would never be able to get away with making in a courtroom. Your reported comments have greatly prejudiced any court proceeding that may arise from the investigation, and they are deeply troubling in light of your refusal to speak to someone who actually has a judicial interest in this matter, i.e., an attorney representing one of the young men unduly prejudiced by your comments. I do not understand why you will reportedly speak to the media in such certain condemning terms before all the evidence is in, but you will not have the courtesy to meet or even speak with the representative of someone you have publicly condemned, despite your knowledge of the presumption of innocence and your position as an officer of the court bound by the rules of professional conduct related to pretrial publicity.
Okay. Mr. Cheshire then specifically draws Mr. Nifong's attention to concerns under the rules of professional conduct.
Yes, sir.
And did Mr. Nifong ever respond to this letter, either verbally or in writing?
Not to us.
And did Mr. Nifong continue making extrajudicial statements after receiving this letter from Mr. Cheshire on March 30th?
Yes.
Mark, I think this would be a good place to take our evening recess. Unless you have something else to ask about this specific exhibit, another line to complete.
If you would allow me 2 or 3 minutes to finish just this one particular line of questioning, I think it would be difficult to break it.
All right, that'll be fine.
I will not be long. After these statements were made, were you familiar with the story on REL the following day on March 30th, in which both Mr. Nifong and Mr. Cheshire were interviewed?
Yes.
Can you play Exhibit 143B?
And yet he is out there saying, not just that 3 of the boys are guilty, but they're all guilty as aiders and abettors. I have not accused anybody of committing this rape. I do believe that a sexual assault occurred.
Cheshire suggests Nifong's vocal and visible stand on the case has more to do with this day's election than justice.
You'll have to ask him. I don't know about his political race. I don't know what his motivation are. There are certain people who told me that the timing of this could not be better for the election. That I had nothing to do with it. Had nothing to do with anything about this other than that. But what happened here...
Can you stop that for just a second, Michael? Can I ask the panel whether you can hear...
I can hear it, but I'm not processing. I cannot hear it very well.
Okay.
Is the speaker on one of these? Sounds like there's something going on with the speaker.
Yeah, so they can hear it. Can we do that?
I know what it says.
Could you please restart it so that I can hear the whole clip, please?
And yet he is out there saying not just that three of the boys are guilty, but they're all guilty as aiders and abettors. I have not accused anybody of committing this rape. I do believe that a sexual assault occurred.
Cheshire, though, suggests Nifong's vocal and visible stand on the case has more to do with this May's election than justice.
You'll have to ask him. I don't know about his political race. I don't know what his motivations are. There are certain people who told me that the timing of this could not be better for the election. That I had nothing to do with the timing of this case. I had nothing to do with anything about this other than the fact that what happened here was one of the worst things that's happened since I have become district attorney.
Cheshire's client, Captain David Evans, is one of three who talked with police and willingly gave a DNA sample. Cheshire says Evans denies any sexual assault took place. Says the last 2 weeks have taken a toll on the student and his family.
I just want to ask people to hold on and pretend these boys might be their own children.
And Nifong would rather people imagine the victim in the same way.
When I looked at what happened, I was appalled. I think that most people in this community are appalled. I think that if Joe Cheshire weren't representing one of the people involved in this case, he might even admit that he was appalled.
Now, the district attorney tells us that...
Did Mr. Cheshire make any indication in that March 30th letter about whether or not Mr. Nifong's comments were putting the defense attorneys in the position with respect to the press?
Yes.
And that interview took place the day after Mr. Nifong received the March 30th letter from your office?
Yes.
That's all I wanted to ask before the break.
All right, let's take a break here, and we'll reconvene tomorrow again at 9 o'clock.